Good afternoon, everybody, and welcome to our webinar, in which we're going to look at what all you need to know about sending your employees from the UK to France. I'm Sarah Bull, and I'm an employment partner in the London office of Birketts, and I've worked for many years advising businesses on cross-border HR issues, in particular working with sending your employees overseas or assisting with employees who want to go overseas to live. And I'm going to introduce our speakers now. First of all, we have Alexandra Dabrovieci, who is our French expert today on this webinar. Do you want to introduce yourself, Alexandra?
Of course, Sarah. Thanks. I'm very happy to be here and to share my knowledge about French law with you. So I've been an employment lawyer in France for more than 15 years. I work at Voltaire Avocats, which is a employment law firm, a boutique law firm, which specializes in employment law and social security law. And I have a specialty. I assist foreign companies which come to France and which want to set up and expand their business in France. And I work regularly with my colleague Sanjay Navy, who is an immigration lawyer who also works with companies.
Yes, thank you, Alexandra. So I'm Sanjay. Hello, everybody. I'm a lawyer for 20 years now, and my job is to help people to come in France, to settle in France, and when they want to become French.
Great, thanks so much. So I'm just going to quickly have a look at what we're going to cover. And the webinar is going to be in three parts. So the first part, I'm going to take you through some of the UK law considerations for when you're looking at sending an employee to work in France on a temporary basis. And then we're going to turn to our French experts. So starting with Alexandra, we're going to have a look at some of the French employment law considerations. And then finally, have a chat with Sanjay about what you need to bear in mind when you're looking at the immigration law issues. So this is the scenario that we're going to be covering today. You're a UK employer. You're looking at sending a worker to France. Your worker, and probably an employee, but not necessarily, has an English law contract, and you want to send them to work to France temporarily. So that's the scenario that we're covering, and there's probably various different permutations of that, but that's the sort of the basic outline. So there's a number of practical and legal considerations for you from a UK angle, and I'm going to take you through the 6 key considerations that we think you really need to be aware of. And these are the first 3 of those 6 on the slide. So starting with number 1, and that's the duration of the assignment. So of course that's going to be largely dictated by business needs. You might just need someone to go to France for a few days, a few weeks, or you might be looking at someone on a much longer term assignment. And you know, they could, for example, be scoping out a new market for you, looking for new customers. So the duration will obviously dictate a lot of what comes next in terms of the immigration and the employment considerations. And if it's clear that you've got a particular set length of time, then that makes it easier to get everything in place at the start. But consider whether you need some flexibility and in your arrangements, in your documentation with the employee and with any third party that's involved in this arrangement as well. So how might you bring this arrangement to an end early, or how might you extend it? Have a think about those things when you're considering what to put in place. And this moves us smoothly into the contract. So first of all, you'll have an individual on a contract of employment, and you want to have a look at what does the existing contract allow you to do. So it's not unusual for contracts in the UK to say that you might be asked to travel as part of your work, and they might specify a maximum duration that you'd ever be expected to spend abroad. So that's helpful, of course, if you've already got that in the contract. if you haven't got a provision like that, or if you actually want to do something that's different to the provision that's in the contract, then you'll need to have the consent of your employee to do that. In terms of looking at recording what you have agreed, it really depends on what the arrangement is. If you're sending your employee to work for a client or potentially another group company, you might want to consider having some sort of comment agreement in place. And it depends really what's come about into how the assignment has come about. And if that isn't appropriate in these particular circumstances, perhaps you're not sending them to a third party as such. They're just going to be working abroad, but for the UK company, then you'll probably need some sort of variation to the contract, unless there's something in the contract that allows you to send them abroad for this amount of time. And even if there is something like that in the contract, is there anything that you need to think about in terms of elements of the contract that will no longer be relevant because they're not in the UK? So have a think about what's in the contract. Is it all going to be still applicable when they're abroad? And typically for an assignment of just a few days, it will be. But for longer term assignments, there's probably a few things that you'll need to change. And then thinking about what law will apply. And I think it really will depend on the length of the assignment and the type of the assignment. But in almost all circumstances, it's probably fair to say that a bit of UK law and a bit of French law will apply. And obviously, Alexandra is going to talk a little bit more about that in a few moments. And from that perspective, you really need to understand, well, what are the potential French laws that could apply? And first of all, you need to educate yourself about what those are. And then secondly, consider whether there's anything that you need to do to make sure you're following that legislation correctly. So these are the final 3 of these 6 considerations that I was going to run through. So number 4 is tax. Now, tax is a really complex area, and it's definitely something where you should seek advice on a case-by-case basis, because it's going to be pretty fact sensitive in terms of what the tax arrangements and situation is. But very much as a sort of broad rule, in terms of a short assignment, you can typically expect that you will continue to operate through the PAYE system in the UK. Again, Alexandra will probably have a few things to say about social security and so forth in a few moments. So that's an individual's income tax, but what about the company and the corporate tax position? So this is particularly relevant when you're sending somebody abroad who's going to try and sell into new markets, who's going to be looking to enter into contracts with clients, and where revenue is going to be generated in that second country. In that situation, it's possible that the authorities where your employee is working are going to be interested in seeing if they can get any slice of that revenue by charging some form of corporation tax to the business. And that's something to be really careful about, because what you don't want is for there to be corporate tax considerations that you haven't taken into account before sending that salesperson into that new market. And finally, immigration. I'm going to leave this pretty much to Sanjay, because really it's about finding out from the French immigration lawyer what you need to do, if anything, in order to send this individual to work in France. And there's going to be a difference between the different lengths of assignments and where that leaves you. And finally, from me, just a few practical considerations. And the first is data protection and confidentiality. If you're sending personal data across borders, the UK data privacy laws are different to the EU privacy laws. So you might need to take advice from a privacy lawyer if there is a lot of personal data going back and forth, to see if there's anything that you need to put into place to ensure you've followed the correct legislation for both countries. And insurance and benefits. So typically your UK employee will have access to a number of different benefits, and might be various different medical insurances. There might be benefits such as critical illness and other types of benefits. And the policies for these benefits might have some specification around where the individual works. And these are things that you'll need to check to ensure that you're not disqualifying them from access to the policy. And normally your contracts of employment will say that they are entitled to have access to certain benefits benefits, subject to the rules of the schemes of those benefits. So if your contract says that, you as an employer are protected if those benefits aren't provided. But on the other hand, you obviously do not want to inadvertently put your employee in a position where they can no longer access a benefit that both you and they were expecting them to be able to access. And they might need travel insurance and specialist sort of travel insurance, and that's something to think about as well. And finally, health and safety laws vary quite a lot country to country. So this is something you need to take into account, whether you need to carry out a risk assessment, for example, even though it's not necessarily a workplace that you'll have control over. So it might be the employee that has to carry it out, or there might be specific legal requirements in France that you need to take into account, which is, again, something that you would need help from a French lawyer with. So that's what you need to think about in terms of from a UK perspective. And moving across now to speak to Alexandra about the French employment law considerations that you need to take into account when you're sending your employee to work in France. So I've got a few questions for Alexandra, and I'll get started if that's okay with you, Alexandra.
Of course.
So thinking about sending the individual abroad, what do we need to do in preparation? What do we have to do before they arrive in France?
So as an introduction, I think it's important to understand that there are different kinds of posting under French law. You have the first situation, the most common situation, where you're going to send an employee to France because you entered into a service agreement and you're going to need the employee you send to perform the service in the framework of this contract. So it is the first situation. The second situation is if your company belongs to a group and you're willing to send this employee to work in a branch of the group or in a subsidiary. So it's the second type of secondment. There is the specific case of temporary work agency. And then, this is important, this is what we called in France secondment on your own account. It means that as a UK company, you're going to send an employee to France, but this employee is not going to perform a service for a client. So there is no client, no service contract. It's just going to work for the company, for the UK company, for your own company. It can be for a meeting with a client or for a training, but there is no supervision of your employee by a host company. It's just you send him and he works for you. And this is important because the formalities won't be the same if you're in this last case.
Yeah.
So this is for the kind of postings.
Okay, no, that's clear. And a temporary work agency, I think is we would call probably a recruitment business or an employment business. So that was the third option, the TWA option. Yeah, and I think most of these are going to be falling within the first one, which is essentially contracting a client. Or the last one where you just need someone to go and they'll still be your employee. Yeah. Okay. So I think there's a few legal formalities as well. Could you take us through those?
Of course. So you have to, there are the formalities from an employment law perspective, and then we'll see social security perspective. So from an employment law perspective, except when you are talking about posting on your own account, because there is not this formality. So for the first 3 cases of posting, you will have to submit a declaration. This is a declaration that you submit to the French government online. The website is called CIPSI. It's a platform, so you can do it online. And this declaration must be made before the start of the posting. So you must do it before. So on this declaration, you will have to fill in information about your own company, about the employee who is posted, and about the work of the mission, and also about the representative you're going to appoint, because the second formality is this one. You have to appoint a representative, and this appointment is made through the declaration. So this representative can be anyone. It could be the client that you have in France. It could be one of the posted employees, or it could be, we have companies which specialize in this service providers who provide this specific service to be your legal representative in France. It's very important to choose the right representative, because we'll see afterwards that she's the one who is going to liaise with the labor inspector and who's going to be responsible for providing the documents in case of audit, and they must be reachable by email or phone because they represent your interest in France. And so that's formality. Also as a formality, if you work in the field of construction and public work, so you have to send, for example, employees on construction sites, there is a specific formality which is to apply for a BTP card. So the BTP card is a professional identification card, and this allows, it facilitates the audit of the labor inspector on the construction sites, because we know that in France, there is a lot of dumping social. They use secondment to, use workers coming from Eastern Europe countries. And so that's why in this particular field, they added this formality to facilitate the audits of the labor inspector. And those formalities are not compulsory for posting on your own account, and some short-term assignments, which are defined by decree, for example, in the field for artists, sportsmen, sportswomen in very specific fields. So this is for employment law.
Right. So there's some specific exemptions there, but it sounds like generally that needs to be done. It needs to be done before.
So each time you have to check
feet.
Yeah. So that's why it's important to be able to know in which case of posting you are, because it determines the formalities you have to deal with.
Okay. And I think you mentioned social security just then. Yeah. Perhaps you can tell us a bit about that.
Exactly. So this is really important, because when you send your employee to France, it means that if you're audited, the labor inspector is going to check where you pay your social security contributions, because otherwise, if you don't pay social security contributions, it's considered as undeclared work. You should pay a contribution, and this is a criminal offense. We'll see that afterwards. So it's important that when you're on the French soil, to be able to prove that you're still paying social security contributions in your own country, in the UK. And the only way to prove it is to get a specific document. It's a certificate of coverage, which demonstrates that you're paying social contributions in your country, in the UK. And so in the UK, you have to reach to the office at the HMRC, I think, the specific office, to get this certificate of coverage. And you must, of course, provide it to your employee and tell him, her, to have it with him, her, at any time to be able to produce it in case of audit of the labor inspector.
So is that this is regardless of length of assignment, then this is something that people need to have.
Exactly, yes.
It's just more likely that you'll get asked for a copy if you're there longer than a shorter period, probably.
Yeah, but the rule is that, I'm often asked this question. Is the risk higher? Does it depend on the length? But theoretically, as the first day, you must have it from the first day on the French territory.
Okay, that's clear. Thank you. So the second set of questions, we're looking at French employment law and to what extent it might apply to your employees who are in France and who might just be in France on a fairly short-term assignment.
Yes, exactly. I know that a lot of people don't understand this rule, but it exists. These rules apply even if you're under a UK employment contract. If you send the employee to France, is on the French territory, so you have to comply with a minimum set of rules, which are considered as imperative rules, and in specific matters only. So it would be about individual and collective freedoms, such as the right to strike, the right to the speech right. It will be all about protection, maternity protection, paternity protection, paid leaves linked to families' events, working time, bank holidays, annual paid vacation days, minimum wage, very important, minimum wage, workplace health and safety, and illegal employment. And this is important to know that those minimum set of rules, you're going to apply the labor code, but not only the labor code. You must also determine the applicable collective bargaining agreement, the industry level collective bargaining agreement, because, for example, for minimum wages or working time, it can contain specific provisions. And an important point to know about this is that to determine this collective bargaining agreement, you're going to take into consideration the activity of the employee, not of your own company. So, for example, if you send an employee to France to repair a roof, you're going to apply the collective bargaining agreement of the building sector, because this is what applies to the activity of the employees, which is carried out by the employee on the French territory.
Okay, so this is very different from the UK employment law position in that we don't have as much collective bargaining as you do in the European Union. So we're not necessarily used to having industry-wide collective bargaining agreements. So I think that's really helpful to understand that if you're going to France, as well as the French law that applies to everybody, you need to apply the collective bargaining agreement. And are these agreements available publicly? How would you get hold of a copy?
Yes, it's very easy. You go on Lille France.
Okay.
It's a public service, and you even have a specific website, Service Public, and they help you. You can put your activity, your sector of activity, and then it helps you determine the collective bargaining agreement.
Okay, that's great. And what's the minimum wage in France at the moment? I'm just wondering if it's higher or lower or around the same as the UK.
Yes, because you have what you call the SMIC, so which is the minimum legal the minimum legal wage, but be careful because you should always check the collective bargaining agreement,
Right.
because the minimum wage can be higher than the minimum wage provided for by law.
Okay. So information about minimum wage will also be in that collective bargaining agreement.
Yes, that's why it's important, because you should also, I'm not saying that it's complicated, but you have to look into the collective bargaining agreement and try to determine the job classification, to which the job classification of the employee. And then according to the level in the job classification, you're going to determine the minimum wage.
Okay, great. So this was the law that will apply to postings of 12 months or less. And then I think you're going to take us through postings of where it's more than 12 months.
Yes, so if it's more than 12 months, it means that you not only have to apply the set of minimum rules we saw earlier, but the whole French Labour Code and the whole industry level collective agreement, with a few exceptions regarding contract changes for economic grounds, transfer, termination, safe voluntary mobility schemes, and fixed term contracts. So apart from that, it means you have to apply the whole labor code. You can ask for a derogation for 6 more months. If you say, okay, I'm sorry, the project was delayed, so I'm gonna need 6 more months. And so if you get the derogation from the labor authority, you will be able to just apply the minimum set of rules for 6 more months. But if it's not the case, it means that the whole relationships is subject to the whole employment, French employment law.
Okay. So there's an advantage to keeping things under 12 months then.
Yeah.
It's a little less heavy on the employment law side. Okay. And in France, you've got the Labour Inspectorate. Can you tell us about what that is?
Yeah, of course. So the Labour Inspectorate is a part of the administration, the Labour administration, which is in charge of making sure that employers comply with French employment law. It means that they can visit you one day without notice, enter the premises, check if you're compliant, ask you for documents to check if you comply with law, question people, asking them questions about their activity, about where they come from. And this is why it's important when you come from another country, when you post workers, to make sure they have everything to show that you are compliant, that they have a work permit, that they have this coverage certificate which show that they pay social contributions. And we'll see that there are other documents, because you also have an obligation to store specific documents that you will have to be able to provide to give the labour inspector in case of audit.
So it's a bit similar to in the UK, we have the Home Office who might do an audit for immigration purposes, but we don't have an inspectorate who will look at broader issues of employment law. So it's a bit like a Home Office plus something sort of audit from that perspective. So I think you were going to tell us about the things that you need, the documents that you need to have in place and the information you need to have.
Yeah, exactly. So regardless of the duration of the posting, so even we were telling for short assignments, you're going to need some documents to be able to show that you're compliant. So any document proving that wages are paid, a statement of hours, which will allow the labour inspector to see when the work day starts and when it finishes, to see if there is overtime which should be paid. Also a document proving an equivalent medical examination, because yes, since as I told you, you have to comply with health and safety rules. It includes the medical monitoring of employees. And so you should be able either to prove that in the country, in the UK, the employee had an examination, which is equivalent to the one in France, or you should use an occupational health service in France. So it can be the one of your client, for example, to ensure that this medical examination. And of course, you should be able to show to produce the work permit if it's needed, and for the UK usually. So we'll see, it can be needed.
And do they need the medical examination regardless of length of time in France?
Yes.
Yeah.
For this, it's regardless of the duration of the posting.
Okay.
Yeah. Or you should be able to show that you took the necessary steps, because in France you have to have the examination within 3 months as from the date of hiring. So, or as that you took the steps to have the employee examined by a French occupational doctor. But I know it seems a little bit complicated, but
yeah, it's not something we would typically do, so it's an unusual step for a UK employer. And presumably the purpose of the medical examination is to ensure that the employee is fit to do the particular role that you're hiring.
Yeah, exactly. Yeah.
Okay.
And so for posting of at least 1 month or more, you will have to produce the pay slips or equivalent documents, because on the pay slips you have much more details about the remuneration, the working hours, the payment of overtime, the payment of paid leave, public holidays, and things like that. The applicable collective bargaining agreement is usually indicated on the pay slip. So if the posting lasts more than 1 month, you should also have pay slips or equivalent of the pay slips. So this is for the information regarding the workers, but we'll see that you also have to be able to produce information regarding the company, the UK company.
So I think this is what you were moving on to, yeah, information related to the
Yes, because of course, when you second an employee to France, so it's true for every country, also the UK, it means that if you don't hire in France and if you don't apply the whole French employment law, it means that you don't have an activity in France. It means that your activity is in the UK. Otherwise, it wouldn't be, wouldn't be compliant for you to use secondment. So you must produce the documents which show that the UK company has a real and substantial activity in the UK. So first, you should be able to produce the UK employment contract of the posted employee, which shows that there is a real relationship in the UK, a real employment relationship in the UK. Any document proving the law applicable to the contract, so usually it's going to be in the contract itself. And also any document proving the number of contracts performed and the amount of turnover in the UK. To show that your activity is really in the UK and you're not using secondment as a way of not applying French employment law. So these are the documents you must be able to keep, and also the certificate of coverage to be able to show that, okay, you post employees to France, but you're paying social security contributions. And you must be able, most of the time, there are some exceptions, but most of the times you must be able to provide those documents at the labor inspector request, which means immediately. And this is why you have your representative in France, because he should take care of it. So either you're going to have those documents on some premises, in France, or you're going to have to set up an online access, like a Dropbox or something like that, so you can have access and produce those documents.
Okay, so it's really clear that you need to have a certain set of documents ready to go
Exactly.
as soon as you might be requested to produce them. And if we fail to do that, and we don't have our documents ready, or we're missing some of the documents, what could the authorities do?
So it's true. I would like to specify that a lot of companies have told me that they post employees in France and nothing happens because they are not audited. And so they don't comply because for them it's so complicated. But I must tell you that when the labor inspector comes, it can be quite expensive. It's going to depend on the number of employees, because now they use an administrative fine. So it means they can issue the fine. They don't need to go, because there are the criminal fines and they need to have the approval from the authority, which, the Procureur de la République, and but for administrative fine, it means that the labor inspector has the power, to notify those fines. And for each employee where you don't comply with the regulation, either we forget the declaration or you're not able to provide those documents, it can be fined 4,000 euros per posted employee.
Right.
So depending on the number, it can go high. And also, when you're in the case of secondment to perform a service provision, the labor inspector can decide to suspend the performance of the service in France, so which is not good from a commercial point of view, of course, for your client. The other risk is that the posted worker could take legal action before the employment tribunal in France, really in cases where, for example, you would not comply with French law, for example, and so it would have a damage caused by the fact, for example, that you don't comply with working time in France. And the sanction, if you prevent the labor inspector from performing his duties. So if you refuse to communicate documents, or if you refuse to let him question employees, there is an offense which is called in French obstacle à contrôle. So it means that you prevent, the labor inspector from doing his job. You can be fined. The fine is 37,500 euros. And there is also imprisonment, but it's quite rare, but so there is a fine.
Okay.
So this is about employment law,
There are some potentially quite severe sanctions, and I think the one that really stands out to me is the fact that they can suspend your performance of the services. So if you're acting for a client and you suddenly can't provide those services, that could cause you a large amount of commercial embarrassment and reputational embarrassment.
Mm.
Okay, well, thanks very much, Alexandra. Oh, sorry, I need to just go back
for
there.
social security.
I think there's one, that was non-compliance with French employment law, but this is going to be non-compliance with social security.
Yeah, exactly. So if you fail to produce the certificate of coverage, it can be a A1 form. You have a fine also. From the amount changes each year because it depends on the ceiling of social security. So for 2024, it's 3,864 euros. So for each employee, of course. And also, but this is what I explained, the certificate of coverage demonstrates that you pay social security. So if you don't have it, and if the authorities, for example, in the UK, challenge the fact that you pay social security in the UK, it means that you don't declare and you don't pay social security. And so in France, it's a criminal offense, undeclared work, because you don't pay the social security. And as you see, the sentences are serious because it can be 3 years of detention, of imprisonment, and a fine. So it depends. For individual persons, it's 45,000 euros, and for companies, corporate entities, it's 225,000 euros.
Right. Okay. So some very serious sanctions then for
but this should be where
security.
I guess that companies coming from the UK should pay social security in their own country.
Yeah, absolutely. Well, thank you very much. I think that was really helpful rundown and quite eye-opening insight into some of the French employment law requirements. So just moving over to Sanjay now and to ask a little bit about immigration law requirements. And I think the obvious question, Sanjay, is will our employees need a visa?
Yes, thank you, Sarah. Well, if a British employee wants to come in France and to work in France, there are two questions. First thing, does he need something he needs to prove that he has the right to come in France, and then he needs to prove that he has the right to work in France. And to check it, it's easier if we distinguish two situations. The first one, if the employee stay less than 90 days in France. Well, it's easy to everybody knows. I think that UK citizens do not need a short-term visa to come in France, so they can stay in France 90 days over a period of 180 days. So they won't need any visa or any residence permit, but they will need normally a work permit. Well, there is three situations. First situation, they have a work permit, but for less than 90 days, I don't think they will ask for it because there is two main problems. First problem, it takes up to 2 months to get the answer from the French administration.
Right.
And also you have to prove that you tried to find someone in France able to do the job, and that you couldn't find someone with the French unemployment agency. So it's very hard to do that. You must post an offer during 3 weeks on the unemployment agency. So 3 weeks plus 2 months, well, it's too long. Most of the time, I guess that British company will do with a second month declaration. But you have also to know that in some specific area, you have work permit exemption. But well, it's for soccer players, for artists and things like that. Please note that for the 90 days, there is two things to keep in mind. First thing is it is not 90 days in France over a period of 180 days. It is 90 days in the Schengen territory.
Yes.
That is to say, if you have spent 2 weeks in Roma or in Barcelona for your vacation, and that if you want to stay 80 days in France, well, it's not possible because you will exceed the 90 days period. And also, if you're traveling back and forth, the count of days does not reset to zero every time you go back to Great Britain. The days spent in the Schengen territory will accumulate over a 180 days period, and then you will count how many days you have spent in the Schengen territory to check during the last 180 days to check if you have exceeded or not the 90 days.
Right. Okay. So it's based on a rolling provision.
Yes. So you have to count and check on your passport all the steps, because it is how the French administration will check it.
And do you find that certainly for people perhaps sending employees to France just for a few days or a couple of weeks, that generally they would just rely on the fact that they can enter the country without a visa for up to 90 days and they're not getting work permits just because of the length of time it takes?
In my experience, when they stay less than 90 days, most of the time, if they want to come in France, they won't be stopped by the customs. But if there is a labor inspector, and if he counts the days, he will do that, and he will say there is a problem.
Right. Okay.
So the problem is when they work, not when they come, most of the time, because The customs from France to Great Britain, the same for USA to France, they do not check really strictly. But if you come from Africa, they will check it day by day. Yes.
Right, okay. And if it's more than 90 days, there's different rules then.
Yes, because there is no exemption for the visa. The UK citizen who want to stay in France or in the Schengen territory for more than 90 days, he will need a long-term visa or a residence permit. So first time you apply for work, a long-term visa to come in France.
Yeah.
And if you want to stay after the duration of the long-term visa, then you will apply for residence permit. And if you want to do that to work in order to work in France, then the worker will need a work permit or a second-month declaration. And he will have to show the work permit or the second-month declaration to the French consulate in order to get the long-term visa, or to the prefecture if you want to get the residence permit. So
Okay.
when you want to come in France for more than 90 days, a British citizen is treated like a Chinese or a South African or a Australian. Well, it's as hard as everyone.
Yes.
As for everyone.
Yeah, we don't get the benefit of the EU anymore.
Yes, but with my experience, most of the time it's quite easy to get the long-term visa. It's easy and goes fast with the French consulate in the UK.
Oh, that's helpful to know. Okay, so if we decide, well, we're not going to bother with that, we'll just send someone over and see how they get on, and then we get caught. What are the possible penalties that we'd need to be aware of?
Yes, there is two main possibilities. First thing, it is an administrative fine, which is up to 20,750 euros per illegal employee. It has changed this year. Okay. And as Alexandra told you before, it's nearly the same. Before, it was another organism who was in charge to ask to pay the fine, but now it is the Ministry of Interior who is able to do that. So it has been changed to be easier for the French administration to ask for it. So we don't have a lot of experience about it because it changed the beginning of this month, in July, the beginning of July. But I think there will be more and more control about it. And it is also a criminal offense to do that. So you risk a maximum 5 years imprisonment and a fine, a criminal fine of 30,000 euros. But when it's your first time, most of the time, they say, well, pay the administrative fine. Maybe you will have to pass an internship to learn, and you have to pay for it to learn the rules in France. That's the first time. So we don't summon you to the court because, well, there is a lot of more serious things to judge in the criminal court in France.
And thanks so much, Alexandra and Sanjay, for joining me to go through this webinar, and I hope that you've all enjoyed attending. We do have time for a few questions, so I'm going to have a look at the questions now, and we'll try and answer some of those.